big event on the agenda today is Mr. Heimer's going to speak to us. But before we get to that, do I have anyone who has a draft bill they would like to present to the committee? Seeing none. We also have on the agenda a presentation about the COMA law, Kansas Open Meetings Act. I'm going to, before we get into that, I'm going to ask if there's anyone here who in another committee has not had the revisers talk to you about COMA this year. So I'm taking that everybody has been instructed on COMA. So in view of that, I'm going to then just refer everybody to the memorandum, which you should have on your desk, which outlines the procedure, and we can forego a second instruction on COMA. All right, then I think we can get on to our main event of the day. Donald Heimer, the Assistant District Attorney for Johnson County. Mr. Heimer, welcome to the committee.
Oh, sorry. I am an Assistant District Attorney in Johnson County, Kansas. I'm speaking to you all today as a representative of the Juvenile Justice Oversight Committee, and I'll explain more of what that is as we go along. It is a statutory creation of Senate Bill 367, and we'll talk about that. But in that capacity, I come to you to give you an overview of what our committee does, which will, of course, encompass a little bit of an overview of juvenile justice in general. But, Chair, I want to thank you and the committee for your interest in juvenile justice and what we do through the Juvenile Justice Oversight Committee. You know, we have lots of goals, and, you know, we've come up with mission statements and purpose statements. I always feel like what we're trying to do in both my work as the chairman of the Juvenile Justice Oversight Committee and my work as an assistant district attorney, and I've been at the DA's office in Johnson County for almost 35 years now, and 33 of those years have been in primarily juvenile-related cases. I've done some other things for the office, but that's always been the primary emphasis of what I've done professionally for all those years. I think we always look to see how we can serve the community in enforcing the laws as they pertain to juveniles, to get good outcomes for public safety, and to get good outcomes for juvenile in terms of treating the juveniles, in terms of treating them fairly, having the appropriate accountability for the appropriate or for their inaction or their inappropriate action as they violate the law. In other words, we want the dosage to meet the crime they have committed. And I think that's also the goal of the Juvenile Justice Oversight Committee and the goal of Senate Bill 367. I think any time you look at assessing whether the outcome was good and fair and just, there is always room for debate in that, and there are different criteria that different people have depending on their perspective. But that's what we seek to do through this committee. I wanted to let you know this presentation, we're a fairly small group. This is a very informal presentation. This is informational. So anytime you have a question, feel free to interrupt. You probably would anyway, but I'm extending that to you. There's nothing super complex or prepared about this statement that would be thrown off by veering a little bit off the prepared path and talking about some issues within juvenile justice, and I'm happy to try to do that. I am here on behalf of the Juvenile Justice Oversight Committee. I was here just a few months ago to the Joint Committee and did present our annual report, which is one of the things we do each year. So some of this, for any of you here who are here for that, some of this will overlap. But I understand many of you are new to this committee, so I want to make myself available to answer any questions you have. Not that I have all the answers, but I've been doing it a long time, and I've fielded a lot of the questions you may have. I'm here with Matt Billinger, who's from KDOC and is kind of the engine that makes the Juvenile Justice Oversight Committee go. And he is here in case there are some kind of technical questions that I may not know in terms of some budget issues, which are always something we spend some time on, as well as he did a good portion of preparing the annual report, which we have with us and I know is available to you all. So,
yeah. Right, right. So, right. So I think today, given the informality, we will permit that. If you would request, yes, you did. I'm
I understand.
not reprimanding.
Okay, okay.
You're good.
You'll have your opportunity later, Mr. Chair, I'm sure.
Sure I will.
Where do I find this report?
I'm sorry?
Where do I find this report you allude to?
Oh, the annual report, it was submitted to the, it's been submitted to you all. It's been submitted.
Okay, then let me inquire of the committee staff. Where do I find the report?
Thank you, Mr. Chair. Jillian Block with Legislative Research. It will be in the S drive in the next 5 or so minutes.
Thank you.
Okay, good. I checked it earlier today and it wasn't there. That was the baseline of my question. Thank you.
All right, we'll start off with the first slide, which obviously contains the first mistake of the day, as it is actually January 21, 2025. But we will move on from that, and I did want to discuss with you what our purpose is through the Juvenile Justice Oversight Committee. And I know we can all read, but this is a short one, so I will just read it. It's to monitor and collaborate with the juvenile justice system agencies and stakeholders to ensure best practices are followed and justice-involved youth receive appropriate supervision, assistance, and accountability, all with the goal of better outcomes for youth and communities. This was to take a larger mission statement and try to make it a little more bite-sized and something that worked better for the community. And we want good outcomes. The purpose is good outcomes. This is the formal mission statement, which is basically saying the same thing, but it talks more about stakeholders and some of the purposes that we have within and statutory duties we have within the Juvenile Justice Oversight Committee. The committee, and we'll talk about its makeup here in a little bit, is a multidisciplinary team. So there are prosecutors and judges, and we'll go over the whole list of exactly who is there. Court service officers or probation officers, some legislators, and we want to make sure we do our best, and that was the purpose of Senate Bill 367, to talk openly and with as many viewpoints represented as possible. So when we look at the history of the Juvenile Justice Oversight Committee, what we have, and I don't know how many of you were in the legislature in 2015, but at that time there was undertaken by the legislature a work group that was looking at the entire juvenile justice system. And I came and testified numerous times on the bill, which later became Senate Bill 367 and was passed into law, on the aspects of the juvenile justice system that were deemed to be in need of change, and some of those things that were deemed to be appropriate. The goal was to keep more children at home, more juvenile offenders at home than were previously kept at home, based upon the changing of the law to make it more challenging and higher levels of crime and higher thresholds to remove children from home, to place them into either detention or group homes, or, in the case of the most serious offenders, the juvenile correctional facility. One of the best things that was done with that piece of legislation, at least in my opinion, was to do away with the ability to place misdemeanor offenders at the correctional facility. It seemed out of line with what we were doing on the adult side. It reduced the number of juvenile offenders who were in the correctional facility. I'm a prosecutor by trade, so I'm all about accountability, but I think it's the right people that need that most serious form of accountability of going into the correctional facility. So the purpose, as we put on this slide, is to prevent deeper dives, as they call it, or pulling a juvenile deeper into the system. At the time, prior to 2016 and the passage of Senate Bill 367, we had group homes for juvenile offenders. And this would be kind of for your mid-level offenders on the sentencing grid. As you are aware, we have a hierarchy of crimes in Kansas, right? We have murder is an off-grid. Then we have a felony strata, which is level 1, things like rape. Then like a level 3 would be an aggravated burglary, all the way down to level 10, which would be a felony theft or a theft over $1,500. And then we have the 3 levels of misdemeanors, A, B, and C. And so the group homes were mainly populated by those committing mid-level felonies and low-end felonies and misdemeanor cases, and they were continually coming into the system. Probation wasn't working, and they were being removed from the home and placed into group homes. The legislature in 2016, in the passage of Senate Bill 367, sought to have that option taken away. So the legislature closed all the group homes, and the money that was saved from the closing of the group homes went into what we'll talk about later, which is the evidence-based fund. There were millions of dollars each year, and I don't pretend to understand the economics of the legislature, but apparently each year that money is still redirected from what would have gone to group homes into the evidence-based fund, although that has a sundown that we'll talk about in a little bit. And the goal was to take that money that we're saving each year, put it into the local communities, and have the local communities have the ability to provide better and more intensive services for those juvenile offenders who are more challenging. In other words, those who don't do well on probation and they fail, or maybe they commit additional offenses. So the purpose was, and it has something that we've been working on since 2016 when the bill passed. Most of the laws became effective in 2017. It was a stair-stepped law, but most became effective in 2017, a few in 2016 or 2018. So the goal was to do that in a way that still protects public safety. In other words, you have some folks that, some of whom are a little bit dangerous, have done some fairly violent crimes, and they're still being left in the community. Senate Bill 367 felt that those folks could be safely kept in the community if they had the proper services. So these services and the things that were put in place have to be supported by evidence, so they are evidence-based practices. So the fund was originally called the Evidence-Based Practices Fund. It's had some different names, but I'll probably still refer to it to that in that manner because that's what I think of it. So the main things that were done with regard to Senate Bill 367, we had fewer children in detention. It was harder to detain children, juveniles, and remember, juveniles are anyone 10 to 18 who violate the criminal code or a status offense. We had fewer of those folks eligible to be placed in detention. We had no group homes because we closed them, and it was harder to place juveniles who committed crimes in the correctional facility. They had to be more serious crimes, and there were more criteria that had to be met. So we had more folks in the community, more folks in their home. We had shorter probations and fewer revocations, because one of the things that was found is, although the number of cases being filed was already going down prior to 2015, the number of juvenile offenders incarcerated was still remaining higher, and in fact, in some places, still increasing. So even though the numbers were going down, the incarceration levels were not following that. And so the bill, Senate Bill 367, sought to lower that. Now, this was very widely accepted within the legislature. Within some parts of our multidisciplinary team that we've talked about, it wasn't as popular as it was in other parts, but we have been working with it since that time. And so Juvenile Justice Oversight Committee, the history of it, one of the provisions that was a part of all those other changes was the creation of the Oversight Committee. And the committee itself is made up of these folks here that are listed. It's a 21-member committee made up of multiple disciplines. There are district or county attorneys, youth services, defense attorneys, Department of Corrections, Governor's Office has a representative. There are 4 legislators, the Office of Judicial Administration. We have victim advocacy, court services. We have 2 district court judges. There are law enforcement. We have a police chief, commissioner of education. We have community corrections and the Kansas Advisory Group. We meet quarterly to talk about all of these issues with regard to juveniles. Currently, our only vacancy is the Senate representative that we have, with Senator McGinn not returning, and we're working to fill that appointment. So we have 20 of the 21 positions filled at this time.
Do you happen to know who the House Democratic member is?
Jared? Jared Owsley.
Excellent choice, thank you.
I've worked with Representative Owsley on many things. He's from my jurisdiction. We've worked together on a lot of child needed care stuff.
Formerly, it was, of course, our colleague Boog Heiberger of this committee, and that's why I inquired. Thank you.
With most of the work, as you know, is in the subcommittees. So we meet quarterly as a group. This group meets quarterly, but we meet more regularly in our subcommittees, of which we have 4 subcommittees: data, communication, reinvestment, and legislative committees. Obviously, we have some ad hoc members because 21 folks divided by 4. We have other folks that bring us information and help us make decisions. Basically, the first committee, data, is probably one of the more challenging committees, because I'm sure you are aware, based on information you've received, our Kansas data lags a little bit behind in terms of keeping track of all our data points within the juvenile justice system. And we'll talk a little bit later, but obviously the new Odyssey statewide program is now fully on board. So hopefully moving forward, we'll be able to track our outcomes better. As we look back, we have spotty data because the DCF and the OJA and corrections and some of the courts didn't all interface very well together. So we're working to correct that. And that has actually been something we've been working on since the inception of the JJOC in 2017. But the subcommittee collects and analyzes data from state agencies and prepares quarterly presentations for our meetings and tries to look at ways we can improve our data collection. And we'll talk a little bit about that as we have endeavored to do so. Our communication committee, one of their primary duties is to prepare that annual report, which comes out every November. And that report takes a lot of time. It talks about a lot of the same stuff we're talking about here, and many of these slides came from that report. So that is a big part of it. Also, that committee works to inform the stakeholders of providers, what's being done elsewhere in the state, trying to help them understand things that are working in other parts of the state or programs that have been effective. The reinvestment group works on monitoring the costs that we have saved and works on that evidence-based fund, and also makes recommendations for allocations. So it's And this is something I struggled with a long time and I've been on the committee ever since it was formed. I've been the chair. This is my third year of being a chair, and I think I'm at my term limit. Actually, I'm actually 1 plus my term limit. But one of the things that is a little complicated is we get to monitor this evidence-based fund. This evidence-based fund is a dedicated pot of money, right? That money is then distributed through the KDOC budget. So we make recommendations based on the work of our reinvestment subcommittee to Kansas Department of Corrections, but Kansas Department of Corrections actually puts it into the budget and submits it through the budget process. Okay? So a lot of times it's asked, you know, what the JJOC is how we're distributing the dollars. We can't actually distribute anything, but we can make recommendations to KDOC. And in the time that I've been working on the committee, we've never had a disagreement. If we've made a recommendation with how to spend those dollars, KDOC is supportive. KDOC obviously monitors the grants. We're not a full-time 24/7 agency that has a large staff to monitor the millions of dollars that we're trying to distribute or help distribute or make recommendations. So we work hand in glove with KDOC. In my experience, there hasn't been any problems or concerns with that. The last committee we added just last year in 2024 is the Legislative Committee. And this committee looks at both responding to new bills and perhaps requesting new bills. The Senate Bill 367, after it passed and became law in 2017 and moving forward, there were no substantial amendments or other juvenile justice bills that came up till last session with House Bill 2021, which gave some greater flexibility to probation. Remember, we talked about how it was harder to revoke probation under the Senate Bill 367. It was so difficult that it made it hard for probation officers to, I guess, encourage the offenders to complete their probation successfully because they knew they had a concrete stop date to their probation, whether they completed it or not. So the legislature put in place the ability to extend that for failure to complete, not unlimited, but to a certain amount, and also put in place the ability to send a juvenile to detention for 24 or 48 hours or 15 days, depending on what type of violation and whether it was their first, second, or third violation. Prior to that time, you could not be sent into detention for what was called a technical violation, like not reporting to your probation officer or having a positive UA or some of those things. Now that is available to the court and can be done on a case-by-case basis. So this committee weighed in on House Bill 2021, for instance, and that was the first time that became something that was really very necessary for our committee to do. Prior to that time, the chair had always been the only person to respond to inquiries from the legislature. We passed some bylaws to make the chair of the legislative subcommittee have that authority as well, and the vice chair would also have that authority, so that wouldn't always be the chair, i.e. me, having to come to Topeka every time something came up. So those are our 4 committees, and that's where a lot of the work is done within our committee. Some terms, and I know we're all inundated with acronyms. I'll try to use non-acronym references when I can. So the evidence-based fund, or now it's just the EB, the evidence-based means practices, policies, and procedures that are demonstrated by research to produce reduction in the likelihood of reoffending. That's a statutory definition from the Kansas statutes. Notice to appear, an NTA, and this is somewhat misleading if you're familiar with law enforcement or if you've ever gotten a ticket speeding, you will get a notice to appear for court, right? And we're used to that nomenclature. That means you're not arrested, it's not a very serious offense, you have a court date. The notice to appear in the world of juvenile justice is, again, it's not a serious enough case for you to have to go and be arrested and taken to the detention center, But instead of giving you your court date, they give you a date to go to the Juvenile Intake and Assessment Center, which is often referred to as a JIAC, and you go to that location and you meet with, essentially, they're like pre-probation. They're the same, maybe the same thing probation workers do, but it's at the front end. They offer services, make you and your family aware of services that might help you. For instance, if your charge was possession of marijuana, or another misdemeanor drug. There would be no reason to arrest you, but you would have a notice to appear to go to the JIAC, and once you're at JIAC, they would assess you and perhaps recommend, for instance, a drug assessment to see if you need drug treatment. And so that is what that notice to appear means in the juvenile world. And then we have the immediate intervention programs, often referred to as IIP. This is more commonly known to most people as diversion. And in the juvenile world, if you commit a fairly low-level offense and you have no priors, in our county and many counties, you can avoid prosecution by doing essentially your probation at the front end. You do the things that are being required of you, do some community service, stay out of trouble for 4 to 6 months, and then the case is never filed and you have no record at all. And that, when we get to the numbers later, when you see the decrease in the filings, I am hopeful that a good explanation for that is that the IIPs throughout the state are becoming more and more utilized and are more effective. Some of the things we did last year in 2024, I don't know how familiar you are with the evidence-based fund, but it usually has, and we'll talk about it later, it usually has a fairly good balance in it. The money has been spent, but spent slowly, so there have been millions of dollars unspent each year. There's always been a concern that that money would be swept for other purposes. Some money was swept last year for other purposes. In an effort to try to make sure all the folks within the system are able to access the funds appropriately, we put in place rolling grant opportunities throughout the year. And what that basically means is instead of having to wait every year or every 2 years for grants, every quarter you can reapply. Many of the folks that are applying for these grants, they have fairly small operations. It's challenging for them to get everything done in a timely manner for just once a year, or things come up in the course of a year or two that need to be addressed. So since July of 2024, we've been able to award $4.8 million through those rolling grants, which effectively kind of become quarterly grants, but officially they're just rolling. That is an unusual practice within government to move that quickly. I think KDOC deserves a lot of credit for working on that and putting that in place with regard to these juvenile grants. And I think it's still early to say, but it seems to be effective in terms of getting the dollars into the right place for the current issues that are facing juveniles. You know, we go from year to year. Since 2017, 2017 we didn't have a fentanyl problem, right? Those things come up year by year. We see an awful lot of stuff with phones. There's a lot of work that needs to be done with kids and their sexting and the other things they do. It's constantly changing, and the system needs to be nimble so that we can react to what's going on, get services in place for each of these new things. So I think the rolling grant, it certainly looks as though it's going to be a big success, and I think it's been a good thing. So those are some big dollars that we've been able to move from the fund out to the local communities, which was the very root of what we were trying to do with this. That's 21.5. We enabled $21.5 million more than last year to roll out this year. With regard to another thing we were working on, I mentioned to you that it's more and more challenging to have children detained in the juvenile detention centers throughout the state. That is primarily predicated upon the use of a standard instrument that all detention facilities use, which is called the Kansas Detention Assessment Instrument, or the KDAI. And there has always been a need to validate that study. We had the CJI work on that, and CJI is Criminal Justice Institute. The Criminal Justice Institute worked on validating that for us. It was not validated, not because it is necessarily inappropriate in its nature, but rather the data was insufficient on most of the categories they were looking at. And so we need to revisit that and move forward. But we did have the instrument validated. We know what we need to have in place to have it validated. A lot of it is data. Some of it may be qualitative in terms of what we put into the instrument. But the primary concern was that we did not have appropriate data to get that done. We also have, and one of the reasons that the grants, I think, have been so successful in terms of being distributed to the local communities is that this isn't something where we want the people that are applying for these grants to become frustrated because it's so challenging, like some federal grant that just has so many boxes you have to check. So we've put in place a lot of help through the Department of Corrections Juvenile Services to have folks on our staff. Some of the staff of KDOC are dedicated to JJOC. We have a couple folks there along with Matt, and I think they've been able to help direct those that are applying for grants. So it isn't a, hey, you got to jump through this hoop. That's all it counts. We want to help understand what you need, direct you, and help you to get that grant successfully submitted, and then you end up with the funds that you need in your community. Another thing that
Excuse me, if I might
Yes,
jump
sir.
in. So, just so I'm clear, the grants are decided by your organization or the legislature or one of the agencies? Who decides who gets the grants?
Yes, it's a joint decision. We make recommendations to have the money go to these certain programs that would be eligible. Then that is then distributed by our group along with KDOC to the localities to say, please put in for these grants. But I think KDOC makes the final decision. We're not in there day in, day out, because we don't have really a staff that would be able to do that. We work with KDOC. So I think the best answer is the budget each year contains the pot of money that is then left to the discretion of KDOC working with the recommendation from the JJOC. So if, for instance, like maybe you have there's a pet project out there that people utilize regularly and it's just not effective. But we've been granting money for it because it showed promise at some point. The JJOC could say, hey, we don't think we should send dollars towards program X anymore because it's just not working. That would then, should inform KDOC to take that off, and then although there might still be budgetary dollars, they wouldn't go for that particular fund. Likewise, if there's one that's been particularly effective, we could encourage it to and commend it to the KDOC, and then they would do the same to the folks that they're reaching out to. So it's not a super clear one person, one responsibility type thing. So some additional things that were accomplished. As I stated, we put together a legislative subcommittee to respond to and recommend legislation as needed. We also have quarterly newsletters that contain our meeting summaries, grant information, and program material. Those are located at the KDOC, on the KDOC website under the Juvenile Services button. Excuse me. So, these are some of our current initiatives. We still have, we are still evaluating some of these new programs that we have been funding. We are exploring, and one of the things that's been, I think, particularly frustrating for us, and I'm sure frustrating for you, is that we don't have the data to be able to fully vet how these programs are how they're operating, how effective they are. We're exploring partnerships with KU and the Criminal Justice Institute, CJI, to continue to improve how we collect data and how we analyze data. As you know, there's obviously a large mental health crisis with juveniles, particularly those 10 to 18, which is the age for juvenile offenders. So we have been working with Stepping Up to focus on the needs of justice-involved youth. So many times, just like in the adult criminal system, we don't want the place where mentally ill juveniles are lodged to be a juvenile detention facility. We want it to be an appropriate mental health facility based on the level of their crime. And if they would otherwise be able to be in the community, we don't want them in detention or a locked facility solely because of their mental health issues. So obviously, we are working to try to make sure there are more resources available for those folks. We are also partnering with the GALT Center, and the GALT Center works with criminal defense, or the juvenile version of criminal defense, juvenile justice defense, to try to educate the defense bar in the juvenile arena. And we've had some trainings. There was in 2020 a fairly comprehensive evaluation. I think it was 2020, I'm pretty sure that's right. Pretty comprehensive training or evaluation and training that was offered with regard to the strengths and weaknesses of the defense that's provided to juveniles in Kansas. We're very hopeful, as I stated earlier, that Odyssey solves some of these data problems. But like I say, we're going to have a point from which we move forward. Going backwards, the data is not going to get any better. We can't go back and remine it because we weren't collecting it. So moving forward, we'll be able to collect it and hopefully evaluate how these things are working. There was another issue we had in 2020, and that was the legislative post-audit. There were several things that needed to be worked on and addressed, and obviously as a committee, we have worked hard to do so. One of our duties is to monitor the evidence-based programs account, which is that fund that we've been talking about, to make sure that balance is utilized for appropriate things and that we keep that balance properly monitored. One of the things when Senate Bill 367 first passed, the JJOC, our little committee, was actually, the language was we were supposed to do the accounting. And of course, we had no, I was like, first meeting we were at, I'm like, I'm a little worried about this. We probably ought to hire an accountant, and I don't know if we have a budget to hire an accountant because we're not, I know lawyer math, and that doesn't get you anywhere near accounting. So I was like, we need to change that. So the one change that was made to the bill in the first few years was to change that to that we are to monitor. So in other words, someone else can tell us what it is. We're not responsible for the, the accounting practices, but we are responsible for monitoring the amount at a more macro level and making sure it's going into the appropriate places and making the appropriate recommendations. So that's one of the things we've been working on. We've been trying to define program outcomes. One of the first things we did is we did come up with a definition of recidivism, because every program, when someone enters into the criminal justice system or the juvenile justice system, everyone wants to know, are they coming back? And that's the really, are they coming back is the really general definition of recidivism. We came up with a specific definition, which is measured by a delinquency adjudication or adult conviction while under court supervision or in KDOC custody within 24 months of discharge. So in other words, we were going to try to monitor how they did for 24 months after getting out of our juvenile justice system, whatever that was, whether that was probation or even a more serious intervention. And we're still working to do that. Again, data has been a little bit of a struggle for us with regard to that. We were also supposed to look for gaps in the juvenile justice system. As you all know, probably better than anyone else, when you try to put a system in place for the whole state, it's very challenging because the needs and resources of the various counties are different. If you're in a larger county and you want to have, for kids who are violent, aggression replacement therapy, a lot of times that's a group therapy. You need to have 8 or 10 kids at any one time to be in that therapy. It's a great program, but it doesn't work in a small community where you're not going to have 8 or 10 kids available for that program at any one time to have a group. So we needed to make sure the things we put in place were appropriate based on the size of the communities and what the communities could handle, what they could support. You know, things like telehealth and lots of other things have been looked into. So when we're looking at gaps, that's something that we're trying to make sure that we work on. The makeup of the committee that I shared with you, it isn't only multidiscipline, it's spread throughout larger, you know, large, medium, small counties so that we have input from all those folks. We also seek to monitor the fidelity of the programs that we've already put in place, as I stated, to make sure they're working. I'm not familiar with any that have come up to be so inadequate that they were no longer funded. There have been histories of that over time. One program that is always kind of a hot topic on evidence-based practices is a DARE program. For whatever reason, evidence-based does not support the DARE programs, but they've kind of been something folks have liked to do. But for instance, if we have a program that's not evidence-based, the definitions within our statute would not allow us to recommend funding for that program. Okay? So, other portions, we've been working. I mentioned to you that we've now have the ability to extend probations and to use a time of loss of liberty for a day or two or a week or two based on probation violations and extensions of probation. We're trying to collect data on whether that's having the impact that folks hoped it would have, which is it discourages the probationers from continuing to violate. We're also working on disparities in mental health treatment. So again, working hand in glove on that. We continue to hear from folks who have information about new programs and improvements for the juvenile justice system. We have recommendations that we have to make whenever, if there were an event that were significant with regard to a juvenile justice recommendation between the Office of Judicial Administration, which is OJA, the folks that operate the court service officers or the general probation officers, versus KDOC, which operates and supervises the corrections officers, we would step in to try to mediate that or solve that issue. That has not been a problem up to now, but that is a duty within the purview of the Juvenile Justice Oversight Committee. One of the things, when we have charted the data since 2017, juvenile arrests have remained below the 2017 averages. So since the passing of the bill, the number of arrests have declined. Those notices to appear that I talked to you about that kind of takes away the necessity of taking the juvenile to the detention center and have them lodged. 80% of those folks go home. I know that next bullet says 67%, but they're going someplace else. Maybe it's a home-like setting, maybe it's a grandparent or something, but they're 20% are, only 20% are being held in detention. So, those are some of the achievements that we've had. Now, I'm going to get into some slides that are a little more numbers-driven, and I'll do my best to explain those, and I may call upon Matt to help me with those. Number of misdemeanor cases have been greatly declining, 78% since 2017. Felonies have gone down 8%. The number of felonies are lower than the 2017 But we have had an increase since the early 2020s, 23 and 24. I know in my county, they went up 21, 22, and 23. So we've had some increases. Overall, we see a decline in juvenile offender cases that have been filed. And I have some slides on that I think are informative. Sometimes these can get a little difficult to see and understand. Also, these were in color, but they came out in black and white, so they're a little harder to see. But the lower number there, these are juvenile intake and assessment. No, I'm sorry. Hold on. My slides got out of order on me here. Well, anyway, so this is immediate intervention programs. The immediate intervention programs, I think, are something that we talked about. This is akin to the diversion that we had. And for the most part, what this means is that you will have, now I got it. So I wanted to tell you, we submitted separately the slides that I was referring to that contain the more drilled down statistical data about the numbers and the filings, and those are in a separate attachment that I did not make a part of this PowerPoint just because it was getting a little graph heavy. So this talks about immediate intervention programs. We're a big fan of immediate intervention in our county. For instance, in Johnson County, we have a youth court for really low-end cases, and this is where the kids come to court in the evenings. They participate as, we use the courthouse. It's not formal court at all. The students are the judges, the jurors, the lawyers. It's kind of a big civics lesson about the judicial system. And for pushing and shoving matches and things at school that are not super serious, but it's caused a problem at school, they come in and they argue over not whether they're guilty or not, but the lawyers argue for less community service hours. The prosecutors would argue for more community service. A jury decides, a judge proceeds, but they're all students. We have lawyers and law students who volunteer to help them present it in a way that's consistent. And we send 100 to 200 through that every year. We also have a pre-file diversion program for first-time misdemeanors, maybe a little more serious than the cases we send to the youth court, but they can have a pre-file offer to just, if it's a marijuana case, go and get a drug and alcohol evaluation, follow the recommendations. Don't get in trouble, do X number of hours of community service, and then you're done. We also have in place a program that's for minors in possession of alcohol, where you, again, you go and get a drug and alcohol assessment, follow the recommendations, do some community service, and you're done. All of these are ways to bypass becoming those numbers that used to be cases filed. And then we still have, once we have filed cases that are even more serious and some low-end felonies, they're still eligible for diversion, so they can avoid an adjudication, but they don't avoid a filing. The reason I bring this up is all programs like that, like those I just mentioned and others in other jurisdictions, they have a very high success rate. And as you can see there, it's over 90% successful. So these kids are not recidivating within the time period that we can keep track of it. Now, we rely largely on the local, the numbers come from the places that have intermediate intervention programs, which not everyone has. That's sometimes a difficult thing for smaller jurisdictions to have a fully operating system, although we're working to try to put that in place. That's something that could be a grant-funded thing if someone wanted to put that in place. Any questions about immediate intervention? It's kind of it's a different phraseology. It's a little different than diversion, because in the adult world, the diversion, the case is filed and then you get diversion. In the juvenile world, we sometimes call it diversion. It's more of an immediate intervention program, and you do it at the front end, and the case never even gets filed. So you don't even have a record of a case being filed. Okay, I think I had one here too.
Thank you, Mr. Chair. these statistics, is this statewide or is this just?
This is statewide. I'm sorry. Yes, this is statewide. All of these numbers are statewide. I just gave, I can't stop the clicker. I gave you examples of some of the examples of IIPs that we have in our county, in Johnson County. So, but the numbers you're seeing here are statewide. The other thing that we've run into, to be very candid about the numbers for IIP, is some jurisdictions are still referring to this as diversion. So getting the proper IIP numbers is a little challenging. I think the encouraging part is it's very effective in terms of diverting, whether we use the term diversion or not. We're diverting people from going to court, which is the goal. I think over time, these numbers will go up because I think more people will report their programs as being IIPs, but right now that's a challenge too, because there's just some definitions that we're working on, if that makes sense.
We have a follow-up from Representative Bressman.
Thanks, Chair. You mentioned that the arrests were declining.
I'm sorry?
You said arrests.
Arrests are declining throughout the state. Those are state numbers.
Is, in years past, a juvenile would be arrested for a certain crime, but now they get an NTA.
Yes.
Are any of those statistics considered?
Yes, those are considered, that's a great question, because there's several definitions of arrest, right? So once you are, your liberty is restricted by a police officer, you're arrested, even if they let you go, right? So that's the number that's going down. It's not just those that are being taken to the detention center to be assessed for whether they should be sent home or not. Okay.
We have one from Representative Seibert.
Thank you, Mr. Chair, and I apologize for being late. I had my interns showed up. So anyway, I had a question. I'm kind of new to this juvenile justice code. I've been working with a customer, or I guess I call them customers or constituents to me, that's had some trouble with some children, but it was in a foster program and it was outsourced to contractors to review of that. Are we outsourcing this stuff to out-of-state contractors?
So is this a foster care situation?
Is it what?
Foster care type situation?
Yes.
So the juvenile offender code is for the 10 to 18-year-olds who violate the law. Probably, not knowing all the facts, what your constituent is dealing with would be a child in need of care type action where he or she might be a foster provider within the system, and they might, within that system, they're going to have subcontractors who provide services, and that's true. Mostly they are in Kansas that I'm familiar with. We have Caw Valley and TFI and several other providers throughout the state. I'm not familiar with out-of-state providers. I know some of the providers we have also provide those services in other states. So I think probably your question is more along the lines, or her question is more along the lines of a child in need of care type action.
Okay, now the children are under 14. They were under 14.
Right.
Okay.
Child in need of care is anyone from breath number 1 up to age 18.
Okay, there's no cutoff at the 14, because I was told there was a difference between 14 and under and 14 above in juvenile offenders.
There are some things that are different. At age 14, that's the age at which you can be waived to adult status if you commit a really serious crime. In the child in need of care world, that's where you have the right to come to your own review hearings, is at age 14. There are a number of rights that attach to juvenile offenders and rights that attach to children in need of care at age 14. But I'm still not quite sure what she's dealing with is a juvenile offender matter unless that child is being accused of a crime.
Okay, and that can go from in-state to out-of-state, whatever you call them.
You can be placed out of state as a foster care participant. If you're in foster care, you can be placed outside the state going through an interstate compact process, but it takes a while, but yes,
Okay,
it can.
well, I was kind of surprised. So thank you for, I don't know, I've been reading through this and looking at this, and it's too much for you, Mr. Chair. Thank you. I'm glad I'm not an attorney.
Thank you. I have a follow-up from Representative Ressman's question about arrests.
Yes.
And going back to the fact that we have seen a decline in arrests. Have you any data, or do you, just from your experience, have any hunch as to the reason for that, the cause?
Well, I think, well, I'm hopeful. The reason is because juveniles are committing fewer crimes. A concern would be that because there was a concern at one point when juveniles were being released that I think police were discouraged to move them through the process because nothing happened. I think we worked hard to let the police know that number one, hopefully that's not happening very often, and number two, we still want to work it through the system and let the system make that decision. It's kind of the old, I'll date myself very much here, but when I was in high school in the 70s and 80s, late 70s, early 80s, the thing everyone thought would happen is if you got caught with alcohol in your car and you were a good kid and you were polite to the police officer, what would happen? They'd say, pour it out and send you home. Well, you know, now that probably isn't going to happen, but it can still come to us and we may choose not to file it, or it may go through one of those programs. So I think our law enforcement partners, at least the ones I work with, know to send them to us. But I did hear that expressed at some hearings that I was at, that became a point of discouragement. I haven't heard that in a while. So I think it's just that numbers may be going down. You know, we had this thing we've never had before, which was the COVID years, where everything went down in terms of offenses. So it's kind of hard to work that into the mix because we're just kind of getting back to normal. We're getting back to the numbers we had before COVID now, which are still down from those high numbers, but the COVID numbers really dipped. You know, as we all know, crime didn't necessarily go up, mental health, and the child needed care cases the representative talked about, those are the things that spiked kind of, you know, during COVID. Dysfunction of folks was what was higher than actual numerically increased crime, for instance. So that's been a challenge for the system. And of course, I think, you know, it feels like a long time ago, but we're only X number of years past that. So I don't know how we're analyzing the data yet. Thank you for that.
Yes.
Thanks, Mr. Chair.
James.
My question is, the success rate you claim, or you state that the success rate that you've had, does the stats, do they just fall off the chart if you have a successful program, the individual reaches 18? Do you still track anything there?
You know, you can. The adult system and the juvenile system, this is something we're trying to correct with Odyssey. They don't interface super well, which has been one of our problems for tracking recidivism on probation cases. So when we're looking at these numbers in terms of success, that's talking about successfully completing the program. So they're done with the program. We don't have the same 2-year look back that we're trying to do. This is, they got through the program and they were deemed successful. So it's a little less of a success story than if we were tracking it 3 years later, or did a look back on them when they turned 21 to see if they've been a productive adult for 3 years. That would be kind of challenging. I'm not sure we have a good mechanism for doing it. That would be a better test. What we have now is these were kids who messed up, made a poor decision, and for the last 4 to 6 months, they've been doing a good job. That's about all we have. Yeah, that's a good question. I wish we had more. All right.
We have
Yes,
another question from Representative Carmichael.
Thank you, Mr. Chair. And at the appropriate time, I'd like to return back to the evidence-based fund. But I want to stay, he invited questions about the slide before, which was...
I'm sorry, I can go back to it.
Okay, I'll remember what I was
IIP?
doing. Yeah, IIP. I think you're telling me that juvenile arrests are down statewide, and it immediately occurs to me, and you're from Johnson County, and we know that DA Howe has a fairly aggressive prosecution program. We've got all kinds of marijuana right across State Line Road. And I would guess that there might be some kids in Kansas that are getting a hold of it. Have you seen an increase in marijuana possession in the juvenile population, at least that you deal with, or marijuana-related crime? Or do we now have this recreational marijuana just across State Line Road, and yet juvenile arrests are going down? Is Steve not prosecuting it? DA Howe not prosecuting? It just intuitively, it would seem to me that this would be a huge problem, and that there'd be all kinds of kids being locked up for it.
I think it is. I think it is a big problem. I think that there's two stats that are kind of mirroring each other here. One, I mentioned the arrest statutes being way down. I don't know, that's a statewide. I'd have to check it for Johnson County specifically. And likewise, then there's the number of cases filed. Possession of marijuana is an offense that's eligible for our pre-file. So we could be arresting them, having the reports, and if the family and the child work on the issues that we've presented to them in terms of getting help and trying not to use marijuana, because that's illegal for every juvenile in the whole country. It's this is a common misconception. No juvenile can legally possess marijuana. It doesn't matter if you're in Missouri, Colorado, or Kansas. It's just the law. And so so I think hopefully the IIP programs are keeping some of those offenders from having to come into court. So I'd have to run the numbers to see how many cases we have filed, say, in the last 10 years. I could do it. In Johnson County, for instance, how many we filed, how many reports we've had, and now, in the last few years, since we've allowed IIPs for marijuana cases, how many of those cases are going to IIP, which means they don't become a part of our statistic base of cases filed.
But the IIP program, people do get arrested before they end up in IIP, so I would have thought that their numbers would have shown up in the data set.
They would show up for arrests, but those are statewide numbers. Those aren't just county numbers.
Okay, well, we can talk later. Thank you.
Thank you. Okay.
Representative
One more?
Neely, did you have a question?
Actually, I had two, but I'm going to save one of them. You spoke multiple times and everything about the Odyssey program, and I have heard from multiple other folks and everything. I'm just curious and everything whether this program, you've consistently said that there are issues in keeping the data, et cetera, the ability to control it. Is the Odyssey program going to function well enough for you to accomplish such a thing?
That's the goal. I'm not a computer person. We had previously, many jurisdictions had separate programs that they used. We had one in Johnson County. There were different programs in different counties. There was also a statewide program that many of the particularly smaller counties were a part of. So, and that was the problem, is that there wasn't one database. Odyssey should prove to be that one database. It should be mining those data points that we need to do what we're doing, to do what we want to do with regard to the look back from November of 24 forward. So at that starting point, we have all the data hopefully going into Odyssey, and those data points can be pulled for the whole state.
I'm glad to hear that. Thank you. Thank you, Mr. Chair.
Okay.
We're good.
Thank you. So the next thing I wanted to spend just a little time on was the cross-systems collaboration. I know the representative's questions about child needed care is always something that comes up. And that is, child needed care is obviously abused and neglected children, juvenile offenders, or those violating the law. Those two cross-sect very often, or they intersect very often, and that's our crossover youth program that we're funding in 3 counties, 1 large county, 1 medium county, and 1 smaller county. We're also trying to work with all of these various agencies to have a collaborated effort to make all the stuff we're talking about work better. I know I've already been going an hour, and I want to be very mindful of your time. Some something that has always been a subject of conversation. I know Representative Carmichael even mentioned, I did want to give you some slides on the evidence-based program account. And I've already been very clear that I'm not great with the math stuff, and accounting is not in any way, shape, or form my gift. But one of our tasks, of course, is to make sure these funds are being utilized in an appropriate manner, that we're good stewards of this money, that it's going to programs that benefit the juveniles that are in the system. It is primarily administered by the KDOC. The statute, which is in the 75-52, 164, talks about those that are eligible for these funds, and it's juvenile offenders and their families. That's number one. Juveniles experiencing behavioral mental health crisis and their families, and children who have been administered a needs and risk assessment. A lot of these, some of those we expanded, or you all expanded that with House Bill 2021 to try to make more families and those who maybe haven't yet violated the law, but they're in danger of that. They're showing risky behaviors. They've been evaluated and they have some risks. Also, the behavioral health crisis designation allowed, for instance, the mentally ill child who's out of control in the home and causing damage, and the police are called. It gave an opportunity for dollars to be spent, even if there's no crime that's reported or it's looked at as a mental health issue, that we can still use these evidence-based funds in the communities to try to provide services for those folks. So the account, just to kind of explain the way it works. That didn't come quite as through in black and white. So what we do in that first box is we identify the need. This is the allocation process. The JJOC Reinvestment Subcommittee works on it, makes recommendations to the JJOC Committee of the Whole, which then shares that with KDOC to have them build that into their agency budget. Then KDOC can negotiate contracts or establish grants to spend that money. Some grants are to local governments, such as your local JCABs and wherever you are from, and then they disperse some of the monies, or it can be a direct or general grant. The evidence-based program will then start up, and then we have the delivery of the services to the community. That's the way it works if it's going according to Hoyle, okay? So this is kind of these are the numbers, the allocations. There's a lot of money in these funds. So the allocations in fiscal year 2022, we allocated $19.5 million, and then it's been in the $37 million for fiscal year 23 and 24, and projected for fiscal year 25, or we've already sent those to be our allocations. So the way that kind of works, there's a beginning balance of $52.5 million. Once we allocate, assuming we allocate all the dollars, there'll be $15.5 or so million in that account. So, and then it repopulates each year. And so the issue becomes, at some point, they stop getting the savings from closing the group homes that we talked about. And this is the latest projection of that those dollars will run out in approximately 2028. So if we continue to spend at the same level, we'll be $18 million in the red. Now, going back to the allocated amount, we may allocate $37 million. Most years, that's not all spent, and some of it, I don't know what the correct terminology is, comes back to us, to our account. For instance, if you're putting in place functional family therapy and you get $200,000 to put 50 families through functional family therapy, but that year you only put 20 through, you're going to return over half the money you asked for. And we're finding that a lot of the money is being returned unspent. Obviously, some of the allocations go to infrastructure, and that money is usually spent. But I think our grantees are being good stewards, and they're returning the money as they do, if they do not spend it. Which, of course, they should, but it's still a good thing that we're able to repopulate it. Probably more non-strictly accounting-based estimate on this would probably have this running out closer to 2030, but it just depends on if we ever get to the place where we get the allocations and the amount spent to be matching up 100%, it's going to push it up closer to 2028. We continue to monitor this fund. I guess we would ask if at any point, any of you become aware of the fact that people are wanting to sweep the dollars for other items. Obviously, it was designed to be earmarked money. We understand that that's a lot of money, that it's there, but we would certainly always like the opportunity to discuss why it's important for juvenile justice. But we understand, things come up and there are priorities. So that is my final formal slide. If there are any questions.
Thank you very much. Does the committee have any further questions for Mr. Heimer? All right. Representative Carmichael.
Thank you, and I do appreciate the explanation at the bottom of the slide set about the balances in the account. Obviously, this issue of use it or lose it, sweep it away, is of concern, and it's very attractive to have a pot of money in government that say, hey, we could take that, nobody's using it, nobody needs it. And I really want to compliment people. It took longer, a lot longer, to start spending these balances down than I had anticipated when I voted for this legislation, I think in 2015. But I'm glad that we're getting there. But I guess the revenue side of this, is it all SGF allocation? Or do you get funds from somewhere else for the evidence-based?
It's in, my understanding, it's an earmark.
So-called earmark.
Right, yes.
So it's SGF money as far as we know. Okay. And what's been the bottleneck? And maybe I ought to just say, don't look back, just look forward, things are going well. But, I had people really upset with me over this bill. Said, we got a kid that's committed 40 auto burglaries in your neighborhood, and the police say we catch him and he's out inside of an hour, inside of 3 hours, so we just don't even bother to haul him down and process him anymore, and there's no place for him anyway. And then I'd look and see that we had millions of dollars that never got allocated. Was the bottleneck in finding the vendors to provide the programming? What happened that put us in that at least temporary fix?
Sure. Well, there's several things. That kid, that offender, would have been in the old system sent to a group home. Rightly or wrongly.
Right.
That's
right. Yeah, and that was the story the sheriff told us.
right. Rightly or wrongly.
We would have locked him up in a group home, which I didn't think was a good idea, by the way.
Yeah. Rightly or wrongly, that's what would have happened. Now we have services in place that are designed to try to curb that behavior. There are probably services in your district that are designed to stop that behavior. And, when I had the hypothetical created or asked, and I kind of created the deal where the police become discouraged, it can happen. We try to work with them to not be discouraged. That's going to be a jurisdiction by jurisdiction case to where police need to work with their prosecutor. My personal belief is the idea of this wasn't to say we're going to give kids a free rein to commit 40 auto burglaries. And we should still, as a system, be able to earmark those who are career criminals versus those who are sneaking out one night and jiggle 3 or 4 car handles. we have to be able to distinguish between those type of burglars, right? Those are they're both guilty of auto burglary, but there's a huge difference, and we know that. So I think the system needs to work to do that. So that really isn't a question to the bottleneck of the funds, because I think the funds are available and have been available that whole time. I believe that offender that you're referring to, when we sent him to a group home, we didn't get great outcomes in the group home, and that's what we learned, right? Well, a lot of the outcomes aren't always going to get better because we're doing it in the community. That's a difficult segment of society to work with. Some kids are challenging. So, you know, if you're not successful in changing the behaviors of a juvenile, I don't know that that is related to the dollars we're spending on them, other than if there is some very effective program, we want to make sure we make it available. But at the same time,
Bus ticket out of state, that seems to work pretty well.
yeah. So, well, that's kind of the issue. Under the old system, maybe the group home didn't work very well, but they weren't living in your community anymore, and maybe that was part
And
of it.
I'm not saying that seriously,
No,
but
but-
one time that was a solution for juvenile crime, was just ship them to grandma in Oklahoma and we won't worry about them.
Right, and,
Or the Army, another example, all respect to the military, which they don't do anymore, I understand.
right, so those are challenges. I don't know that I can find a causal link between that scenario, which I know does happen, and the evidence-based fund, because I think we're trying to get that money out. To try to answer your question as to the bottleneck, based on the success we've had with the rolling grants, I think the bottleneck was a lot of people are intimidated by grants, and we had to try to make them less intimidating and easier to get. So not that they're not quality programs, but we're helping them to get it done as opposed to sending out a criteria that's very complicated. We're trying to help the applicants express what they're trying to do so that we understand and so we can give them grants on a quicker basis.
Mr. Chairman, I do appreciate the committee's work, and I hope you'll take back my thanks to the committee members for the work that they're accomplishing. I think we're on the right path. It's just been a bumpy road.
It's been a long road and a little bumpy. Yes, thank you.
Yes, Representative Seibert.
Thank you again, Mr. Chair, and thank you for your presentation. It's kind of interesting. I agree with my colleague and the representative and my attorney. That's his interpretation. Anyway, on a different subject, but the same as my colleague answered, we've been broken into several times. You know, I live outside of Wichita, about 25 miles, and the sheriff in both counties know the person that's done it. He was charged with 75 vehicle thefts. He was deported 3 times. He's been in prison. He's been out. He's been in prison. He's been out. And now my wife got a notice from the court system that he's on not probation, but work release, to be careful, because since he did break in the house and stole some items, including a couple guns, that we need to be on the watch. This isn't like it's a first-time offender. Maybe we can meet and help me explain this to my neighbors, because my sheriff, which I'm meeting with in a couple days, has the same question. And some of these, they know these guys by heart, but they don't get incarcerated. And I goes back to the juveniles I was talking to earlier. I can understand a juvenile. We raised 8 foster kids, and we understand kids could get in trouble and things like that, and they try to rehabilitate them. But when you're a career criminal, but he said it costs more to deport them back to south of the border, but they're back before they can get the papers filed. And he says, quote me if I'm wrong, I'm not sure how to say it. The governor says as long as it's a victimless crime, we will get reimbursed for our insurance, so it's not worth incarcerating them. Is that a true fact or not?
Well,
That's what my sheriff told me.
well, that's a tough question to answer, but I'll try to sift it through the lens of juvenile justice. It sounds like that's an adult, for one thing. So I'll try to answer it through a juvenile justice lens. Our juveniles who may be here illegally, they have a whole different process. And if we have, again, juveniles who commit 40 or 75 crimes, I believe the current system that we have has the ability to recognize that those are, even if they're younger, even if they're 16, 17, that they're kind of career criminals. And the system has the ability to have the accountability be loss of liberty if it gets to a point where it's serious enough. We have to look at each case on a case-by-case basis. We have that structure of crimes, which I told you is murder, and then level 1 through level 10. Even in the adult world, you're only pretty much presumed to go to prison at a level 5 and above. So something like a burglary to a home should be presumptive for prison for an adult. It would be presumptive for the correctional facility for a juvenile. But you need to look at each case on a case-by-case basis. So I don't think there's anything within Senate Bill 367 or the current Juvenile Justice Code that mandates that those people cannot be prosecuted and that we cannot seek incarceration as the accountability for them. Now, every case is different, so I have no idea what's going on with those cases, and I'm not commenting. I'm just saying I think the code has the ability to try to hold serious and chronic offenders accountable. It's not easy. It shouldn't be easy, but we have the ability when we identify people who are risks to the community. If you look at the Juvenile Justice Code, even the rewrite with the Senate Bill 367 language, community safety is still very much number one. And so we can still hang our hat on that. But those mid-level crimes, which some auto burglaries probably fall into that, that's the challenging area that I think the system has struggled to come up with a really good way to handle those offenders if they're chronic. And so I think that's a challenge that's out there. I'm certainly not here to say that Senate Bill 367 answers all the questions and solves every problem, or that the Juvenile Justice Code is perfect. But I do think there is the ability within the current code to hold offenders accountable. And I think we're seeing that we still need to have those things in the code, while at the same time trying to give the less serious offenders less involvement in the system, which I think is the ultimate goal of Senate Bill 367. People can debate if it went too far on the mid-level crimes. It was certainly good for the lower crimes. The really high-end crimes didn't really change. The murders and the ag robbers can still be treated the same.
Just one, I'd like to make a comment. Thank you. That was a pretty good answer. That was one of the questions I visited with our sheriff and some of the people that we've had. Being so close to Wichita, we've been a tremendous amount of break-ins in the rural areas. And he was talking about the habitual criminal acts, and what they're saying is in the letter that my wife got, that even though he's not considered stealing a car, he breaks into your house and steals the keys, it's not considered a felony theft. And that was where he says they can't prosecute him. But the question he's worried about is, will they turn into more of a habitual crime? And I'm saying if that right, I'm not an attorney. My attorney's sitting over there. There's certain technical terms that he's afraid that you can't use, and that was the question. It goes back, and I'd like to visit with you personally on that other one sometime. So thank you very much. You got a tough job. I don't know how you do it. Thank you, Mr. Chairman. I appreciate it. And I always joke, I was in prison for 22 years myself, so I got to know a lot of these people, and it's, you guys do a tough job.
And for what reason were you there? You want to clarify?
I'm going to plead the fifth or whatever that is.
Okay.
Thank you.
All right, Pastor. Very good. It's, any further questions? We have a couple more minutes if anyone wants further information. No. Well, thank you so much, Mr. Heimer, for coming in and talking to us, and we'll be in touch because I'm sure as we work through the session, we'll need more of your information and advice, and sage that it is. Thank you.
All right, thank you very much. I appreciate all your work, and we're always happy to answer questions as they come up.
Thank you again. We're adjourned.